Hello everybody, my name is Ismail Shahtakhtinski. I'm the immigration lawyer at ISLAW firm. I just came out of the asylum interview, remote attendance with the Arlington asylum interview for a client of mine from one of the Asian countries whose asylum application we filed in 2016. The applicant came into the United States in 2016. He fled from severe persecution by the government of his country because of his oppositional views. He's a member of an oppositional party and has been active. He had high-ranking positions in the oppositional groups in that country, and that's why he was severely targeted and threatened by the government authorities before his arrival in the United States. He had to actually at one time flee his home and has been in hiding for some time before he was able to come to the United States. So this application was filed in 2016 with the Arlington Asylum Office and has been pending for a little over 6 years. And finally, today we had his interview. Everything went well. The officer was very thorough, very detailed. But one of the interesting aspects of this case was that this applicant hired us to also process a employment-based EB3 immigrant visa application through his employer. As you know, the asylum applicants, as long as they file asylum applications within 6 months within 6 months of losing their status, as long as they don't remain in the United States more than 6 months before the asylum application is filed, then they can technically become eligible for EB3 as long as it's processed through the U.S. consulate abroad. So because they don't have status in the United States, they're not eligible to adjust status, but they can go through the U.S. consulate. What we do is we obtain advance parole, we go through the labor certification process, and so on, and then at the time when the time comes for them to go to leave the U.S. for the interview, then we obtain advance parole to allow them to keep their asylum claim while they can travel to the U.S. consulate for their immigrant visa interview based on their employment. So long story short, that's what we were doing for this particular client. And at the time when we applied for advance parole, the USCIS went ahead and scheduled an interview for his asylum case. Now, we don't know if it was a coincidence or if the USCIS, us filing the petition and then which got approved, and then filing the advance parole, the travel document to allow the applicant to travel abroad while his asylum case was pending, whether that triggered the asylum office to go ahead and schedule his interview or not, we don't know, and they don't disclose that information to us, whether that triggered it. But I do suspect, because we had another similar case. It was also an asylum applicant who had a marriage-based case filed. It was a marriage with a permanent resident, so since the spouse was not a U.S. citizen, the beneficiary had to be on a valid status. But she was not, so we had to do the same thing. And once we filed for advance parole for the applicant beneficiary to leave the U.S. without losing their asylum, the pending asylum, the USCIS Asylum Office went ahead and scheduled an interview for her asylum case. At that time, she already got her permanent residency through U.S. consulate, and then she entered the U.S. and became a permanent resident. So at that time, she already was a permanent resident. So in that case, we basically simply withdrew her asylum application. But one caveat in that type of case is that once you file your asylum application, everything in your asylum application, in your claim, has to be true. No matter if it's a weak case or strong case, as long as it's true, you're not going to have problems down the road. But sometimes applicants believe that if they withdraw their asylum case, that's it, then it goes off the record, and then they can file adjustment of status or immigrant visa processing through consulate without any issues. No, the issue is that they are always going to be questioned about the basis for their asylum to verify that there was no frivolous asylum application, which would put a permanent bar for any kind of immigration benefits. So it's very important to pay close attention to this. Now, in this case, there was the asylum interview went very well. The asylum officer, just like in any other case, usually issues a paper asking the applicant to come back to the asylum office to pick up the decision within 2 weeks. But I'd say in about 90% of the cases of the asylum interviews, and we have multiple interviews throughout every week, I'd say in about 90% of the cases we observe, they end up calling us saying, don't come to pick up, we don't have the decision yet, because the asylum officer is not able to make the decision, whether it's background checks or whether there is some kind of nuance about the case, or most of the time it's because they don't have enough supervisors, they're overwhelmed, they don't have enough time to review, the supervisors to review and bless the decision of the officer. So, we are often asked by the clients whether the fact that their asylum decision is delayed, is it good or bad? Does it mean anything? In the past, we were able to somehow gauge whether it was because they are doing background checks, because they want to approve. And in fact, asylum officers used to issue recommended approval decisions and then do the background checks. Nowadays, they don't. So the delays in the asylum decision after the interview don't mean anything. But fingers crossed, we think that the interview went very well. Very well. The applicant was very well prepared and answered questions very well. So we're expecting approval sometime soon.